Hello students. Today we are going to discuss about the one of the important another questions of contract 2, that is define contract of indemnity and what are the rights of indemnity holder. So it is one of the most repeated question. Contract of indemnity, which has been defined under section 124 of the Indian Contract Act, which says a contract by which one party promises to save the other from losses which caused to him by the conduct of the promiser himself or by the conduct of any other person. It means here two parties are there. One is a person who promised to save the other and another is to whom the promise is given. A person who gives the promise to save the other, that person is said to be an indemnifier, and to whom the promise is made, that person is known as a indemnity holder, or also indemnifier is also known as a promiser, and indemnity holder also known as a promisee also. So here two parties are there, one is indemnifier and another is indemnity holder. Now we will discuss about some of the example of contract of indemnity. The first example is a railway company have certain goods to deliver, but the problem is there are two persons who claiming the goods by saying they are the owner. Now the railway company is under the confusion to whom the goods is to be provided. So the railway company has given a goods to the A person, and while delivering the goods, railway company take a indemnity bond or make a contract that if B becomes the real owner, then whatever loss a railway company has occurred, that loss should be compensated by the A. By this, the contract of indemnity is formed between A and railway company. Here railway company is the indemnity holder and A is the indemnifier. Another example of the contract of indemnity is that is a indemnity bond. If a person who lost his original share certificate, at that time also he can apply a duplicate certificate to the company, but while a company issuing a duplicate certificate, at that time the company asks to the shareholder that you have to be give a indemnity bond, because if that original certificate is produced by any other person, the company will suffer loss, because two times company has to be pay the amount. That's why the company is issuing a duplicate share certificate. At that time company makes a contract between a shareholder and companies, that is if any person who produced the original documents and claim the share certificate or whoever it may be, at that time the whatever the company suffer loss, that loss should be compensated by you. So this is a again contract of indemnity. So in this example, who is the indemnity holder and who is indemnifier? So here who is the promiser and who is the promisee? Who is giving a promise? The shareholder gives promise to company that if any loss occurred to you by producing a original share certificates to you by any other person, if such things happens or occurs, I am promised to save you from loss. So that's why here the promise is made by the shareholders. That's why the shareholder is called as a indemnifier, and company becomes a indemnity holder. So another example we can take and we can easily understand the concept, that is insurance company. It is also one of the best example for the contract of indemnity, that is a insurance. But all insurance all not comes under the purview of the contract of indemnity. Only general insurance can be covered under this, because life insurance is not a contract of indemnity. As we know, indemnity means to compensate, isn't it? So a life cannot be compensated. That's why the life insurance is totally not cover this type of contract. Therefore, general insurance such as fire insurance, life insurance, sorry, marine insurance, or accidental type of insurance, motor vehicle insurance. So these are the general insurance, and this covers under the contract of indemnity. Now we will discuss the second part of the question, that is rights of indemnity holder. Here, indemnity holder has certain rights which are given under section 125 of the Indian Contract Act. So according to this, the indemnity holder has three rights. The first one is all cost, second one is all damages, and third one is all sums. So these three rights are very important. So all damages, all cost, and all sums. So all damages means here whatever the indemnity holder suffer loss, such all loss he can recover from the indemnifier. If due to contract of indemnity, the indemnity holder suffers any loss by file a suit against him by any other person, for such a suit, if he suffer any damages or he has compelled to pay any such type of damages in that particular suit or case, such all damages indemnity holder can recover from the indemnifier. It means during this contract, if I have gave one example in this video, that is a railway company. In this example, A, B, and railway company, three persons are there. So two persons are claiming the goods as a owner, but railway company has given a goods to A. And while giving those goods or rendering those goods, the railway company makes a contract of indemnity. Here, railway company is the indemnity holder and A is the indemnifier. So here we are discussing the rights of indemnity holder. It means we are discussing the right of railway company, because railway company is a indemnity holder. Now the indemnity holder or railway company has the first right to all damages. If so, railway company has given a goods to the A. Now B is another person who files a suit against the railway company for claiming the goods, and during this the court gave the decision in favor of B and compel the railway company to make the damages or compensate that particular B. Now here the railway company has to pay or compensate the B, because court has given order like this, and the company has to follow the order of the court. Now here whatever the damage railway company is giving to B, all such damages he can recover from the A also. It means that is the right of indemnity holder to recover all such damages which court compelled to pay him. So here court is compelled to railway company to pay the damages to B, and all those damages he can recover from A. Very simple. So next right is all cost. So here during this, If a railway company B file a suit against the railway company, B has filed a suit against the railway company. Now railway company has to defend the suit. It means railway company has to appoint a lawyer, he has to appear the court, and so many things are there when a case file against railway company. So whatever the cost paid by the railway company, all those costs railway company can recover from the A. And third one is all sums. In certain cases, there may be chances of a case has been filed, but still the case is going on. During that, the railway company and B, they want to compromise it, or they want to settle the case. So if there is any settlement between the B and railway company, at that time, whatever the sums the railway company has paid for the settlement, all those amount or whatever the sums is there, that sums he can recover from the indemnifier or A. So that's why here these three rights of the indemnity holder have against the indemnifier. It means the railway company can recover all these types of rights against the A. So another important thing is that when the indemnity holder claim the third rights, at that time he has to take the permission from the indemnifier before going to compromise or finalize or settlement amount. The indemnity holder has to give the notice of that particular compromise and amount. Then only he has a right. Without the consent or without the notice of the indemnifier, if the indemnity holder make a compromise, such compromise sums he cannot be claimed from the indemnifier. So this is one of the condition we can say. So like, share, subscribe the channel for more such type of videos. Thank you.